Good day to you. This week's tutorial arises from a series of questions asked by John Yates, Karin Kutsia and Leisha Hodson on the discussion forum in regard to prescription of levies. Now, prescription is a relatively complex legal subject, but I will try to set out in plain language the principles that apply to prescription of community scheme levies. As you will see from my pictures, I try to illustrate that this has nothing to do with prescription drugs, nor does it have anything to do with the prescribed rules. In this sense, prescription has an entirely different meaning. It means when a claim becomes unenforceable. So in the context of this lecture, I will be dealing only with community schemes losing the right to sue for outstanding levies. Let's start with the usual overview. What is prescription? Why do we have this legal rule? What is its purpose? There's a Prescription Act of 1969 I just want to sensitize you to. How does all this apply in community scheme management? And then, having explained the basic legal rule, I will explain to you a number of important qualifications, how prescription can be interrupted, how there can be delays in its completion. I'll give you a summary, I'll raise a question which begs from the whole story, and then I'll finally give you a quick restatement of the learning. So let's start right at the beginning. What is prescription? Well, it's a rule of law that may take away a person's rights when those rights haven't been exercised for a considerable time. And to give you some examples, there's a type of acquisitive prescription by which you can acquire rights. You can acquire ownership of a part of somebody else's land by using it in an uninterrupted fashion without admitting that it's theirs for a very long period. You have to do so openly, and the period in that case is 30 years, as you'll see. Another example, much closer to home for the purposes of this tutorial, is that you can lose the right to enforce a legal claim by not exercising that right for a long period. And the long period in this case is 3 years, very much shorter, but still a long period after it arises, and that's known as extinctive prescription. Today's entire video tutorial will be concentrating on extinctive prescription. So why do we have a rule like this in the first place? Well, there are two classical examples. They are first based on older common law writings, is that a creditor has a duty to take action against a debtor within a reasonable time, and if he fails to do so, then the debtor should be relieved of the obligation. A second and more modern explanation is that it's important to have legal certainty. There's an awful lot of information around, and a state of affairs that seems to all the world to exist for a considerable period of time should in fact be given legal effect. And it has been commented that these are two sides of the same legal coin. There is an act, the Prescription Act of 1969. Now, this act doesn't cover every aspect of prescription as it applies in the law of South Africa. It only codifies certain aspects of that law. So the common law rules, insofar as they don't contradict anything that's in the Prescription Act, which I'll probably put up in the library, they remain applicable. I wanted to make it clear that there is a statute that deals with this subject, but I'm not actually going to go through its terms in any detail. I will unpack what I see as the rules relevant to extinctive prescription of community scheme levies in this lecture. Now, extinctive prescription periods under the Prescriptions Act vary considerably. And just to give you some idea, if you have a debt which is secured by a mortgage bond or a judgment debt, or if the state or a municipality has a claim against you for taxes, then that won't prescribe. That debt won't become unenforceable due to its non-enforcement for a period of 30 years, a very long time. There's a period of 15 years that applies to debts due to the state, for money loans and for the sale or lease of land. Perhaps they think the state is a little less efficient in collecting its debts, so should have a longer period. There's a 6-year period applying to debts arising from negotiable instruments like checks or notarial contracts. And then, right in the scope of what we're talking about today, a 3-year period that applies to any other debt, which includes community scheme levies. Now, how does this concept of losing your rights when you don't enforce them apply in community scheme management? Well, prescription starts as soon as a debt is due. Now, that phrase isn't defined in the Prescription Act, so the common law applies. It isn't necessarily when the debt first arises, but when it becomes due, when the amount is known and when you know when you've got to pay it. If levies are raised on the basis, as they normally are, that they will be payable in instalments due for payment each month, then each instalment only starts to prescribe when it remains unpaid after due date, and that whole prescription period then starts to run. Now, there are some important qualifications to the rule of losing your right to enforce a claim. The first thing is the interruption of prescription. If the debtor acknowledges liability in some way, either expressly or impliedly, so expressly would be a clear admission of the liability, signing an acknowledgement of debt, for example, or writing a letter saying, I know and I admit that I owe this money. Impliedly would be saying, can I have some more time to pay this debt, or something that isn't direct but indirect. But if ever there is such an acknowledgement of debt, express or implied, then that stops prescription running. Your 3-year period stops and then starts again. The very next day it starts afresh. If the due date, for example, on a levy is postponed by agreement between the debtor and the community scheme, then prescription starts to run the day after the new due date. Also, the issue of judicial process, the service of a summons, for example, will interrupt a prescription. Any process in which the creditor claims payment of the debt. Interruption, of course, continues as long as the creditor continues to proceed with the action for debt recovery. But if the creditor gives up that action, stops taking action, then prescription will again start to operate. There are also provisions for a delay in the completion of the period. The Act provides for a delay in the completion of the extinctive prescription period in a number of cases where the creditor is under some form of disability or suffers from some form of impediment. In other words, the creditor is actually or may be prejudiced in the ability to bring the claim. And examples, there's a whole list of these things, but examples that illustrate the point are if the creditor is a minor, if the creditor is insane, if the creditor is situate outside the Republic, was married to the debtor, if the debtor and the creditor are partners. In all those circumstances, there is a delay in completion. But the most important for the purposes of this particular lecture are those contained in Sections 13E and 13F of the Prescription Act. There's a delay in completion if the creditor is a juristic person and the debtor is a member of the governing body of that juristic person. Also, there's a delay if the debt is the object of a dispute subjected to arbitration. And, so you need a second thing, the prescription period would have been completed before the impediment ceased to exist. In those circumstances, the period then is extended so that it only completes a year after the impediment ceases to exist. Let me just summarize that, say it again in a different way. If the community scheme levy debt becomes due, but the creditor is a juristic person, as a community scheme always will be, and the debtor is a member of the governing body, or if there's arbitration proceedings and they are commenced, then prescription runs as normal, but the 3-year period is extended to run until 1 year after the impediment ceases to exist. A question that naturally arises is, are all owners members of the community scheme's governing body for the purposes of this, or only the trustees, only the executives? Well, in practice, it's only the executives, such as trustees of a sectional title scheme, who could frustrate the scheme's ability to act to collect a levy debt. So, by analogy with company law, where the courts have held that the impediment only applies to directors, it is submitted that this provision only applies to levy debts due by executives or trustees. Now, this is not completely beyond dispute. I have heard of some arguments that no, it applies to all owners because they are members of the body corporate, and the body corporate is properly seen the governing body. But that wouldn't serve the original purpose of this type of protection. So I submit that that's probably not going to be upheld by the courts. Let me give you a restatement of the learning that I've tried to pass across in this video tutorial. A community scheme debt prescribes or becomes unenforceable if it is not either admitted or legal action is not taken to collect that debt within 3 years of the date it becomes due. Prescription can be interrupted by the debtor acknowledging that indebtedness or by the service of judicial process in order to recover that debt. The running of the prescriptive period is delayed either if arbitration is commenced or when the levy is due by a scheme executive, for example a trustee, so that the scheme's right to collect the debt doesn't expire until 1 year after that situation, which hampers the creditor, ceases to exist. Thank you for watching this Paddocks Club tutorial, and I hope to hear from you on this and other subjects in the discussion forum.